Okay.
Jurors entering the courtroom.
Welcome back, folks. Good seeing you again. Let me turn back to the people of the state of Florida to call their next witness in this case.
State call Don Hughes.
Do you swear affirmatively the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
Watch 2 steps and cheers on wheels.
Good afternoon, Mr. Hughes. How are you today?
Good afternoon. How are you, Judge?
Good. If you could just take a moment and introduce yourself to the folks on our jury and spell your last name for our court.
My name is Don Hughes, last name Hughes.
Thank you. Ms. Walters, you may proceed.
Thank you. Where are you currently employed, Mr. Hughes?
At the State Attorney's Office, White Collar Crime Division.
Is that here in Holy County?
Yes.
The one just across the street?
Yes.
What is your current job title in the White Collar Crime Unit?
Fraud Analyst.
And how long have you been a fraud analyst?
This is my 10th year.
At the State Attorney's Office?
Yes.
What about before the State Attorney's Office?
I was a securities litigation paralegal.
And how long were you, just pull that microphone just a little closer to your mouth so you can hear you. How long were you a paralegal for?
4 years.
Do you have experience in working at the State Attorney's Office for 10 years and as a paralegal before that, and looking through voluminous financial documents and trying to synthesize them down?
Yes.
Okay. Did you receive a numerous amount of records in regards to the state of Florida versus James Scandirito II?
Yes.
And in looking through those records, did you have an opportunity to see bank records, employment records, lease records, and bills for the defendant, in this case, James Scandirito II, as well as James Scandirito Sr.?
Yes.
Okay. I want to start chronologically with you with some of the documents that you looked at. Did you have an opportunity to review the real estate earnings of James Scandirito II?
Yes, I did.
Okay. I'm approaching.
All right.
Yes, Ryan. Mr. Hughes, without testifying about anything before 2013, did you have an opportunity to look at some of the real estate earnings of Mr. Scandirito II from 2013 on?
Yes.
And in looking at those records, I'm going to approach you with 144. Let's start with A. Where was the defendant receiving real estate earnings from back in 2013?
I believe it was Mettler. Yeah, Mettler Toledo Realty.
Okay. And in looking through those documents from Mettler Toledo Realty, did you get a sense of the documentation of what his earnings were?
Yes.
And what was the earnings that he received from Mettler Toledo in 2013 until he finished working there?
I'm going to sustain the objection. Can't testify to documents that are not in evidence.
Did you have an opportunity to look at those documents?
Yes.
Okay. Did they have a business record certification with them?
Yes.
Your Honor, at this time, Statement of States Exhibit 144A into evidence.
Are these the records of the defendant from that company?
They exceed your order. Yes.
Okay. Let me see up here, Ben. When you say the exceed your order, so what I want to do is I'm going to look at the whole study of the jury and set that for the jury to make the records.
144A.
All right, I'm admitting 144A over the defendant's specified objection with the redaction that we discussed here at the bench, and I'll now turn to Ms. Walters.
And Mr. Hughes, I'm going to show you states 144B and 144C as well. Are these additional records of the defendant's employment records from working at real estate agencies?
Yes.
States 144B, what is the real estate company that he's employed there?
MMD Realty LLC?
And did you have an opportunity to look at those records?
Yes.
Your Honor, at this time, Statement of States Exhibit 144B with the business record certification attached into evidence.
Ms. Ramsey? Is it? All right, that will be received without objection.
And what about 144C?
It's records from Mackin Realty, Inc.?
And is there a business record certification?
Yes.
And did you have an opportunity to look at those records?
Yes.
Okay. In looking at those three compilation of records, and we'll get to the fourth in just a minute, but in looking at those three, from 2013, when does the defendant stop working, according to the records, at Mettler, Toledo?
Are you referring to the first exhibit then? Is that
States
right?
144A, those records.
2015.
Okay. Based on the records you observed from the other real estate companies the defendant was employed at, were you able to see when he started working at those companies?
MMD Realty was starting in late 2015 into 2016.
Okay, and how long was he at MMD Realty for, according to the records?
It was just under a year.
Okay. And you were able to view from the records the total employment income of the defendant from MMD Realty?
Yes.
Okay. And what about in states 144C?
You have not offered those.
See?
You didn't.
I apologize, Your Honor. 144C, are those records that you viewed for the Mackin Realty?
Yes.
And in viewing those, do they have a business record certification?
Yes.
Your Honor, at this time, Statement of States 144C into evidence.
All right, 144C will be received without objection.
And when, according to the records, is the defendant starting to work at Mackin Realty?
Late 2016 through mid-2017.
Okay. Did you also get an opportunity to review documentation, we'll mark it as states 144B, of the defendant's employment at Holdbacks?
Yes.
Okay. And you reviewed those records?
Can I see that?
All right, what?
One moment, Your Honor. I believe we gave it to the defense to look at.
It says that. Here. Do you have, what is the exhibit number you want?
It's 144D.
144D. Okay, it has not been provided to Mr. Hughes up here on the stand yet.
That's correct.
Okay, it's in your hand.
No. I think we're going to use it.
Okay.
So that's why I didn't some of this information and just going to come back.
All right, folks, I'm sorry for that delay. I'm going to bin 144D with a possible redaction, and that is without objection except for the one document that we will discuss in after the two reviews this evening. All right, 144D is in evidence.
Thank you, Your Honor. Did you have an opportunity, Mr. Hughes, to review 144D?
Yes.
And what is the real estate company with which the defendant was employed in 144D?
Colfax Realty International.
And, Your Honor, that's admitted into evidence?
It is?
Okay. What time frame from the records that you observed did the defendant work at Colfax Realty?
August of 2017 through March of 2018.
In reviewing these documents, did you get a sense of, were you able to see in the records the income that was coming in for the defendant starting only from 2013 on?
Yes.
Okay. Please relay to the jury what you observed in the records and can summarize in the records for the defendant's income starting with Mettler Toledo in 2013.
2013, there's a W-2, total wages $137,951.16.
And what about in 2014?
There's a W-2, total wages $222,943.87.
2015?
The W-2 total wages $34,583.46.
And is that at the end of his employment at Mettler Toledo based on the records you see?
Yes.
Okay. What about the next real estate company, MMD Realty? And that states Exhibit 144B. Are you able to see income?
They provided a payroll register for the time period of December 2014 through December 2016. Total wages, $61,666.67.
Okay. Any additional income that's coming in from MMD Realty that you observed?
No.
Okay. What about, and when does that employment end according to the records? When do the records end?
I don't believe I saw a date. It was in 2016 sometime.
Okay. What about states 144C, Mackin Realty? According to the records, when do you see that employment begin?
There's a 1099 here that shows total wages of $15,576 for 2016.
Okay. What about 2017?
There's a 1099 that shows income of $27,733.12.
Any other income coming from Mackin Realty that you were able to observe in the records?
No.
Okay. And finally, what about Colfax? What's the term of employment that you're able to see, the years or the dates for the defendant for Colfax Realty?
They provided a 2017 1099. It's hard to read. Total salary $26,708.00.
And are you able to see from those records, skip that one, from the rest of the records, are you able to see when employment checks actually start coming to the defendant from Colfax Realty?
August of 2017, and the last check is March of 2018.
Okay. In reviewing these records, can you summarize for the jury what the defendant's income is from these realty companies, just generally from the years 2017 to 2018, both with Mackin and with Colfax?
For 2017, a total salary, and that's combining Mackin Realty and Colfax Realty, was $54,441.12. And in 2018, which is just Colfax Realty, it was $8,100.
And that is all the way up through April of 2018?
March 19th of 2018.
Okay. Is there a period of gap between the real estate records that you were able to observe where there's no income coming in from real estate organizations?
And between May of 2017 and August of 2017.
So for that 3-month period, you don't see in the records income coming in from real estate?
Correct.
Okay. I'll take this back. Did you also have an opportunity to observe records relating to the defendant's lease?
Yes.
Was that the Avenue Loft condominium lease?
Yes.
Your Honor, permission to approach.
This states 160.
Permission to approach?
I'm sorry?
Permission to approach, Judge?
The witness.
You may.
I'm showing you states 160. Do you recognize states 160?
Yes.
Are these the records you reviewed for the Avenue Loft condominium?
Yes.
Is there a business record attached to that?
Yes.
Your Honor, at this time, State moves States Exhibit 160 into evidence.
All right. The position of the defense with Exhibit 160.
No objection.
All right, they'll be received without objection.
Can you summarize for the jury when the defendant begins to live in this apartment?
The application date is November 2015.
And what is the agreement, according to the records, for the amount of the rent starting?
It was $2,750 per month.
Does that ever increase, according to the records?
It does.
Is that in December of 2017?
I believe it was.
And what is it increased to?
$2,800 per month.
Okay, thank you.
Did you also have an opportunity to review James Scandirito II's Bank of America accounts?
Yes,
Well, I should say one account.
correct.
And in viewing those voluminous records, did you have an opportunity to create a summary?
I did.
Okay. Permission to approach, Your Honor?
All right.
I'm approaching with State's Exhibit 148 and 149.
Do you recognize each of these exhibits?
Yes.
And what is State's Exhibit 148?
It's the Bank of America account ending in 2688 in the name of James Anthony Scandirito II.
Okay. And is there a business record attached to that?
Yes.
Your Honor, at this time, State moves State's Exhibit 148 into evidence.
148, is that right?
Yes, Your Honor.
Position of the defendant. All right, that will be received without objection is the next State Exhibit.
And you mentioned that you created a summary. When you create summaries of bank records, do you alter any of the data?
No.
What are you simply doing with this data?
Taking the transactions from the statements, putting them into Excel, and then you combine in deposits, withdrawals, wire transfers, any additional information that are included in these certified records into one summary format.
And is this the record that you actually produced in State's Exhibit 149?
Yes.
And that's a fair and accurate summary of the Bank of America records ending in 2688?
Yes.
Your Honor, at this time, State moves State's Exhibit 149 into evidence.
The summary.
The summary chart.
All right, that will be received without objection as the next State Exhibit.
Okay. In the summary chart, when does the summary begin when the defendant starts using Bank of America?
Well, the summary started in December 2016, but the Bank of America account had been active, I believe, since 2015.
And did, at that point in time in 2016, did it appear to be the primary account for the defendant in 2016?
Yes.
Was it the primary account before 2016?
There was a Jpmorgan Chase account 2014 to 2015.
Okay. And were those records voluminous as well?
Yes.
Your Honor, I'm approaching with the order showing defense counsel State's Exhibit 159 and State's Exhibit 160.
You already have a 160, so you need to give it another number. 159 and what's the next number?
Well, I have 160 to show you, so judge numbers are all over the place.
I know. 159 and
We have 159 and we have 160.
what is 160? It's not in the description.
I just got it. It's hourly on the minimum records.
Oh, okay.
But there's also a 159 already.
All right, so it needs to be, well, let's keep moving down. 164 there for now. 163 in.
164.
So we 164, 165, okay? Please remark them.
Sure.
There are two exhibits, right?
They are.
All right, are these bank records?
They are.
Of whom?
Of the defendant?
Is there an objection to those bank records?
I have an objection to the summary.
On 164 and 165? All right, so I'm going to admit 164 and 165. You need to lay a predicate as to the summary chart, which would be 166, okay?
Okay. In looking at, first we'll look at State's 165. What do we see in State's 165?
So Jpmorgan Chase account in the name of James Anthony Scandirito ending in 3171. Yes, ending in 3171.
And is that a bank account for the defendant?
Yes,
Is it one of the bank accounts that you went through voluminous records?
yes,
And in going through those, well, at this time, State moves State's Exhibit 165 into
She had
evidence.
no objection. I've already admitted 164, 165.
That's fine.
What she has an objection to is your proposed
That's
166, which is a summary purportedly of 164, 165. Lay a predicate for the summary.
Yes, Your Honor. In looking at that summary, do you see the bank account associated with that Chase summary?
yes,
And who created this summary?
I did.
In creating the summary, did you alter any of the information from the bank records that are in 165?
No,
Did you compile this summary from 2014 to 2016 of those Chase records?
yes,
Is this a fair and accurate depiction of those records in summary format?
yes,
Your Honor, at this time, State moves State's Exhibit 166 into evidence.
Does it purport to be a summary of only 165, not 164? Is that right?
Yes.
Okay. All right. Ms. Ramsey, did you have any voir dire on this or argument?
Well, I just received,
The summary.
yes, that's my objection, is I have not had a chance to look at them, compare those two records. The return of respect.
I'm sorry?
Friday.
All right. All right, let me see the attorney's office. All right, folks, I'm just going to turn back to the Assistant State Attorney to ask her next question of Mr. Hughes.
Thank you, Your Honor. In looking at the Chase account for the defendant, in this case, James Scandirito II, were you able to observe what the starting balance was and when it was actually started?
December 17th of 2014, the beginning balance was $56,054.36.
And if you could just give the jury a snapshot of what you see over the course of 2014 to 2016 in the records about this particular bank account.
You see deposits and withdrawals, as you would typically with a checking account that someone's using for their living expenses. But over time, the $56,000 balance eventually goes down to zero.
At any point in time, does it dip below zero?
Yes, it does.
And when does that occur?
August of 2015?
And does it occur more than once?
Yes.
Okay. When is the account, according to the records, stop being used, this Chase account? In States 165.
September of 2016.
Okay. And does that kind of correspond to when you see records from Bank of America ending in 2688?
Yeah, Bank of America, you see an uptick in activity in September of 2015.
Okay. In looking at the records of the Bank of America account ending in 2688, did you see a difference in the records of how the transactions are occurring in the Bank of America starting from 2016 to 2018 as you did in the Chase account that was from 2014 to 2016?
But generally, yes.
Could you please describe for the jury what the records reveal?
Generally speaking, you saw the balance never really go above a few $1,000s except for particular deposits that were coming in. And there were certain expenditures that you didn't see that were recurring expenditures in the Chase account. And early on in the Bank of America account, that stopped at a certain point.
And what's the starting balance in the Bank of America account starting in December of 2016?
$1,987.45.
If you could flip ahead to March of 2018, what do we see the balance March 1st of 2018?
$117.39.
And as we get closer to the end of March, say March 20th, what's the account balance for this Bank of America account?
March 20th.
Mm-hmm.
Well, the business day ending March 19th, it's $6.05.
And how high does it get between, if you could just explain in the records, if it ever gets above, say, $50 between March 20th and March 28th?
The highest balance was $126 on March 20th.
Okay, and what happens after March 20th?
It goes down to $1.07 by March 30th of 2018.
Okay, on March 27th of 2018, what is the account balance?
At the end of the day on March 27th, it is $89.61.
And what about on March 28th?
It goes down to $3.40.
Okay. What about March 29th?
There is no activity on the 29th.
And the 30th?
It goes up to $61.07 and then down to $1.07 by the close of business on March 30th.
Now, before this time period of March 2018, are you able to see income coming in and income going out for this entire bank account?
Yes.
Does it appear, according to the records, to be almost instantaneous, that when something is deposited, it is withdrawn?
With a few exceptions, generally yes.
Okay. If we go back to March of 2018, do we see any transactions starting on the Bank of America account March 30th and beyond? Are there transactions that are present?
On April 2nd, there is a deposit from a company called Stripe, $1,453.29.
And are you able to see where that transaction is coming from?
Just from looking at the Bank of America records, it's coming from Stripe.
Okay. Did you have an opportunity to actually look at some of the Stripe records?
Yes, I did.
Your Honor, I'm showing defense counsel what's been marked for identification in State's Exhibit 152.
Mr. Hughes, I'm showing you State's Exhibit 152. Do you recognize what these records are?
They're certified business records from Stripe, Inc.
Are these the records that you just testified about that you actually looked at and examined for this case?
Yes.
Your Honor, at this time, State moves Exhibit 152 into evidence.
Position of the defense.
No.
All right, they'll be admitted without objection.
Were you able to see in looking at the Stripe records who the Stripe records belonged to?
Mr. James Scandirito.
And is that reflected on those records?
Yes, it is.
Are there also a series of email accounts associated with those records?
Yes.
And is the Stripe records registered in any type of corporation name or business name?
Leads to closings.
And did you have an opportunity to look at records that involved leads to closings as well?
Yes, online.
Okay. Well, what about from the Florida Division of Corporations?
Division of Corporations, correct.
Okay. Your Honor, I'm showing defense counsel what's been marked for identification in State's Exhibit 154.
Mr. Hughes, I'm showing you State's 154. Do you recognize what that is?
Yes, Department of State, State of Florida, business certified records for leads to closings.
Your Honor, at this time, State moves Exhibit 154 into evidence.
Ms. Ramsey?
No objection.
All right, that'll be received without objection as the next state exhibit.
And who is leads to closing according to these records registered to?
A James A. Scandirito II.
Okay. So you looked at the Stripe records that were registered to leads to closing, and you looked at leads to closing that's registered to James Scandirito II?
Yes.
Okay. Do you see any additional Stripe activity after March 30th of 2018 on the defendant's Bank of America account?
There was a second transaction from Stripe on April 11th.
And what was the total amount of that transaction?
The deposit in Bank of America was $7,476.40.
And were you able to see, based on your review of the records, where that was coming from?
Through the Stripe records, the both payments were processed through a Capital One credit card account.
And did you have an opportunity to look at the records for that Capital
Yes, I did.
And who did that Capital One credit account belong to?
James Scandirito, Sr.
Your Honor, I'm showing defense counsel what's been marked for identification as State's Exhibit 158.
I'm showing you what's been marked for identification in State's Exhibit 158. Are these the Capital One records of James Scandirito Sr. that you reviewed?
Yes.
Your Honor, at this time, State moves State's Exhibit 158 into evidence.
All right, they'll be received without objection as the next State exhibit.
In looking at these Capital One records, did you see a corresponding transaction from James Scandirito Sr.'s account about what you just testified to?
On March 29th of 2018, there was a payment to Leads to Closings in the amount of $1,497.
And do you see that that transaction on March 29th of 2018, is that also reflected in the defendant's Bank of America account?
Yes, after March 29th, there's a little bit of a delay. It is eventually deposited on April 2nd of 2018.
So what does that mean in reviewing the records, that a transaction occurs but it doesn't come in right away?
Sometimes it takes a day or two to process transactions.
Okay, so according to the Capital One records, that transaction happens on March 29th.
Correct.
And then that amount, does that go through Stripe?
It does go through Stripe, eventually into Bank of America.
Is
2688.
that why it's flagged as Leads to Closing LLC?
Yes,
Okay, because it goes through the Stripe account.
correct.
And I think you mentioned that there was a second transaction that goes through Stripe. Can you just tell us about how that's reflected in the Capital One records?
On April 8th of 2018, there appears to be a payment to the Internal Revenue Service in the amount of $7,700.
And were you able to actually look and see if that payment actually went to the Internal Revenue Service?
It did not.
Where did it go?
Into Mr. Scandirito's Bank of America account ending in 2688.
And how much was deposited and when was it deposited?
It eventually was deposited on April 11th, 2018, in the amount of $7,476.40.
Do you know if Stripe takes a little bit of a fee off the top when you use their processing?
There is a fee. So the Stripe records show the initial amount charged to the Capital One account and what was actually deposited into Bank of America.
Okay. Do you see any other additional charges in the Bank of America account ending in 2688 after March 30th of 2018?
Charges? No.
Okay.
Expenditures? Or
Sure.
deposits? There's a April 2nd, 2018 purchase at the UPS store. A April 3rd, 2018 purchase through Google.
And that Google, did you see that and how much was that payment to Google for?
$20.
Do you ever see recurring payments in the Bank of America records for Google?
Yes.
Okay. Did that appear to be an automated transaction based on the records?
No, I think the amounts differed, the times differed, and sometimes it would say Google and then would have another reference in there to where the payment was processed through Google.
Okay. What's the next set of transactions that we see?
There's a $1.99 payment to Google on April 4th, 2018. A payment to FedEx office of $41.73 on April 4th. Again, on April 4th, there is a cash withdrawal of $1,400. There's a chargeback of $9,500 on April 6th of 2018.
Tell us about that $9,500 charge. Chargeback, I think you called it.
Correct. It was a check that had been deposited on April 3rd of 2018, check number 1010.
Were you able to see in the records where that check was written from?
From a Northern Trust account ending in 1584 in the name of James A. Scandirito.
I'm showing defense counsel with the marked identification as State's Exhibit 150.
two 158s.
150, 150.
Was it before that, that was 158?
Yeah.
Yeah, there was already a 158 Friday.
Is there a 150?
No.
Okay, that's what this is. They're not sequential.
I understand that. So the 158 strike, the Gmail,
Gmail extraction
It's
was 158,
158.
but I believe that was
Right.
158 that was already marked. And it had just omitted, so I think there's two 158.
we'll make it right now. What is it? What do you have in front of you? The last exhibit that you were looking at, what account was that?
I believe that was a capital one.
What's the number on that there?
158.
158 for Capital One? We're going to make that 150 for the Capital One account, folks. I'm sorry for that. Steve changed the number on that. It'll be 150.
Thank
Okay.
you, Your Honor. Yeah, go ahead.
And Bree, is 152 available and 151?
151 and 152.
I have the same objection as we discussed Friday about
On
Northern Trust.
the Northern Trust, and I overruled that objection on Friday, and I will admit the Northern Trust records over the defendant's specified objection.
Thank you, Your Honor. Your Honor, at this time, we would ask for Your Honor to read evidentiary stipulation number 2.
Hang on 1 second.
And we'll mark this as 151.
Okay, folks, a stipulation entered into between the state of Florida and Mr. Scandirito. On May 17th, 2017, following the death of Terry Scandirito, who was the defendant's biological mother and the decedent's legal wife, James Scandirito Sr. received an insurance death benefit of $50,082.19. On May 23rd, 2017, James Scandirito Sr. gave his son a check in the amount of $5,000 from this account. On August 18th, 2017, James Scandirito Sr. gave his son a check in the amount of $4,500 from this account.
Thank you, Your Honor. Mr. Hughes, you have in front of you State's Exhibit 151. What is State's Exhibit 151?
Records from Northern Trust.
Your Honor, at this time, State's Exhibit 151 into evidence.
Yes, that was over Ms. Ramsey's objection, and I received it already, yes.
Thank you. And what's reflected in those Northern Trust records that you observed, Mr. Hughes?
That was of relevance to my review was a $9,500 check dated 3/29/18.
And when
Check
do you
number
see
1010.
that? Do you ever see that check actually clear in the defendant's bank account of Bank of America?
It does get deposited on April 3rd of 2018, but then it gets pulled back, charged back on April 6th of 2018.
Okay. Bree, is there a 156?
No.
I'm showing defense counsel Leslie Marshall identification in State 156. Mr. Hughes, did you have an opportunity to review some records relating to James Scandirito Sr.?
Yes,
In addition to the Capital One, did you have an opportunity to look at Wells Fargo and Chase?
yes.
Mr. Hughes, I'm approaching with States 156.
What states 156?
Jpmorgan Chase records in the name of James A. Scandirito, account number ending in, this is a loan account, ending in 0403.
And that's James Scandirito Sr.'s account?
Correct.
Does it have a business record attached?
Yes.
Your Honor, State moves States 156 into evidence.
All right, 156 will be received as the next state exhibit without objection.
You mentioned a loan account. What is that loan account for?
It's a car loan for a 2012 Toyota Prius.
And in Dad's account, or in Dad's name, what is the monthly payment that you see in the records for that Toyota Prius?
$157.36.
And according to these records, who is paying for that? Where are these payments coming from?
James A. Scandirito.
Okay. Were there additional records that you looked at from Chase for Mr. Scandirito Sr.?
There was a checking account ending in the number 1955.
And is that the checking account that's linked to the loan account that you just mentioned?
Yes.
And do you see those payments reflected in those accounts?
Yes.
Okay. And what is the ending balance of that Chase account for the records that you have?
As of April 13th, $372.67.
Okay. In looking at those records, do those payments appear to be regular to the Toyota Prius?
Correct. Same day of the month, March 13th and April 13th.
And is there any indication on those transactions that they're automatic payments?
Doesn't specify, it just says online payment to auto loan of
Okay.
403.
And you're able to see those for which months according to these records?
For March of 2018 and April of 2018.
And when you looked at the records that actually document the auto loan, when did those payments start?
These records began February 24th of 2018.
And they reflect those monthly payments to the Toyota Prius? Okay.
Correct.
Okay. Did you also have an opportunity to review some Wells Fargo records of James Scandirito Sr.?
Yes.
Madam Clerk, is there 157? No. Showing defense counsel seats 157. I'm approaching the State's Exhibit 157. Do you recognize what these are?
Certified Wells Fargo records for an account ending in 9629 in the name of James A. Scandirito.
And, Your Honor, at this time, State moves 157 into evidence.
Position of the defense, 157. All right, that'll be received without objection as the next state exhibit.
And these are the Wells Fargo records for James Scandirito Sr.?
Yes.
And what months do you see reflected in these records?
It's March 20th, 2018 through April 18th of 2018.
And can you tell from the records the transactions that start occurring on the beginning of March 2018?
There's a beginning balance of $606, I believe, and 80 cents. It's blurry.
That's okay.
There's a purchase on the 20th at Osprey Point Golf,
And how much is that purchase for?
$72.
And what else do you see in those records?
Same day purchase, Cross Creek, COUNTR in Fort Myers.
Okay. In the week of March 20th of 2018, do you see any purchases for Costco gas?
On March 26th of 2018.
And how much is that for?
$35.
Okay. What's the next transaction you see on this Wells Fargo account after the Costco gas purchase?
There's a check, 2138, in the amount of $37.
What else do you see?
There's a savings account transfer of $2. We purchased at South Winds Golf in Boca Raton,
And how much is that purchased for?
$46.22.
And what date is that?
The purchase looks like it was March 28th, but it comes out of the account on the 30th.
Okay, after March 28th, do you see additional purchases on this Wells Fargo account?
On March 29th, there was a purchase at Publix for $39.50. That comes out of the account on March 30th.
Was there an additional purchase on March 29th?
There was a second purchase on March 29th at Publix in Boca Raton for $37.41. That also comes out on March 30th.
What do you see next?
Another savings transfer of $3, and then a purchase at Walgreens on March 30th for $7.02. That comes out of the account on April 2nd.
Any other additional purchases on that Wells Fargo account?
Another savings transfer. There's a check that comes out on April 3rd for $110.
And
Check.
what is the ending balance of that Wells Fargo account?
As of April 4th was $4,148.97.
Okay.
Madam Clerk, 153? Yes. 154? Yes. 155? No.
I'm approaching the State's Exhibit 155. Mr. Hughes, did you also have an opportunity to review some additional car information relating to James Scandirito II, as reflected in the Chase records?
Correct. It was a Chase auto loan.
And when is that Chase auto loan begin? And what type of vehicle is it for?
December 13th of 2013, and it is a used, let's say 2011 Mercedes-Benz EC.
Your Honor, at this time, State moves State's Exhibit 155 into evidence.
Position of the defense. All right, that will be received without objections the next day exhibit.
In looking at the records for this Chase auto loan for James Scandirito II, are you able to see monthly payments?
Yes.
And when the beginning of this auto loan occurs, are the monthly payments appear to be consistent?
Yes.
And what is the amount that is due on this Mercedes auto loan?
Roughly $767.
Okay. Does there come a point in time in the records that that payment stops being made?
Around July of 2016, I believe. September 2016.
And how long does that continue for?
Till January 31st of 2017.
And in January 31st of 2017, what happens to this Chase auto loan?
The remaining balance of $20,239.50 is charged off.
And what does that mean?
The bank clears the debt.
Okay. Do you see any additional payments that are made to this Mercedes Chase auto loan, or is it closed?
It's closed.
Okay. Did you also have an opportunity to review additional, I know these are a lot, but additional bank records of James Scandirito II in the form of a credit card?
Yes.
Okay. Did you also have an opportunity to review records in the form of Comcast invoices?
Yes.
Okay. Let's start with the Comcast invoices. Madam Clerk, do you have a 157?
Yes.
158, no. 159?
Yes.
165?
Yes, your next number will be 167.
Thank you. I'm showing defense counsel states 167.
And that was, what exhibit now, is that one?
167.
And is this an exhibit that we discussed Friday afternoon?
No.
All right, folks, let me give you a 10-minute break in the back. And the stretch will come back out. We're going to continue with our direct examination. And we will take care of this legal exception. Yeah, you can step down, Mr. Hughes, get a glass of water, get a drink, get the restroom, and get you back here in 10 minutes, okay?
Thank you.
All right.
Okay, Judge.
160.
Yes, my objection to the Comcast judges, this is something that was recently turned over to us, but you can see from the state's request that they request back to 2017. The only records that they seem to get are February, March, and April, which show no payments. I mean, my issue is really like, I don't know that you can say that that's necessarily his account. There are no payments ever made on it.
For those 3 months.
Yeah, and there's nothing before that because they requested it before that. They requested it back in 2017. And there's nothing.
You got free cable service for 2.5, a year and a half.
No, I don't think that there's any proof that you think people
I don't think there's any proof he had cable at all.
Well, there's Comcast transactions in his bank records.
So, what is this record, what's the relevancy of this not paying his bills, right? Is that what we're showing? Okay. And what is the proof that this is his cable bill? Well, it's got the address, his apartment, I got that. It's got his name,
That would be the
and it has a charge, 160.91. 160.91. And then, what they did was what a cable bill company would do is they keep your cable on, but they add on your new charges to your past due charges.
No, but Judge, if you look at the last page, you'll see that the state requested these records from January of 2017, and there aren't any. So they only have these 3 transactions. I mean, what the state's saying in terms of there's a charge on your account, it's from it says a $50 flat fee Comcast per hour on February 1st, 2018. And I don't know that these are related, and there's no other Comcast charges on his account ever.
All right, what are the records from 2017 show?
There aren't any. There aren't any. He didn't have cable.
And then they're billing him.
So, I mean, he's not paying it. I don't know what to tell you. I don't see what the connection is.
Well, the connection is James Scandirito, 445 North Andrews Avenue, apartment 201, Fort Lauderdale, Florida.
That doesn't mean that he opened that account and that he was using cable and then he knew about it. It doesn't.
When did he get his cable installed? Do you
He
know?
doesn't have cable.
Judge, the records are the records. I mean, the relevancy standard for those records is whether or not they're.
Well, tell me about it.
That is what we have, that was printed out from Comcast. And they clearly are removing certain pieces of information in those records to benefit whoever's account that is. But the point is, it doesn't matter when he opened it. In the months leading up to the murder,
Do you
these
know
notes.
any of this? You're
No.
making argument. I asked you a factual question, and
No.
then you give me argument. Factually, do you know when he opened the account?
No,
Do you know what the account was for?
no.
Does it indicate on the account what it is for?
It's a Comcast bill. It could be for,
I mean, there's a combination of,
I don't
I mean, cable, internet. I mean, what is it? Internet? Is it what service is being used? prior to the...
Can I look at it, Nora?
All right.
And Judge, I would like to put on the record that defense has had these records for,
That doesn't make them relevant.
no, it does not.
That's what we're talking about, relevancy.
Correct. Do you see? Okay, so the Comcast Broward transactions
What are you
actually
doing? I'm sorry.
occurred.
What are you,
I'm looking at this summary that's now in evidence. It's on the defendant's bank records for the Bank of America account. He's making payments to Comcast of Broward
okay, and,
in February of 2018.
okay, all right, thank you. All right, Ms. Ramsey, is that your objection, relevancy? Ma'am?
Yes.
Overruled, I'm admitting it, thank you. Okay, and what else do you got, Steve, with this?
The only other additional records are what defense has mentioned.
What, answer my question directly, what is it, what else is it?
Left, his credit card.
The credit card statement of the defendant.
Correct.
Okay. Is there going to be an objection to that?
Well, it's from 2016 and 17, so I do object based on relevance.
Okay, I'm going to overrule that objection. I'll admit his credit card records from 2016 and 17 over your objection. And what else is there?
He's going to testify about the summaries now that all of the records are in.
Okay, all right. In other words, from all those records, all right? Yes?
Yes, Your Honor.
And then we'll have cross, redirect, and then after this, what witnesses did the state have?
Tim Fay, Detective Joe Noyes.
And Tim, what are they going to testify to?
Tim Fay is the gentleman that performed the analysis of the phones and the laptops and searches, and also retrieved the audio files. And Detective Joe Noyes is the one that mapped the directionality of the phones, and also testified the WhatsApp voice recorder.
What's the relative length of the direct examinations of each of those two witnesses?
I would say for Detective Fay, probably 30 to 45 minutes. For Detective Noyes, it's a little bit longer because of the PowerPoint presentation for the travels of the defendant, so probably close to an hour.
Okay, so we can, I don't know how long Ms. Ramsey has on the cross of the financial witness to see. My recollection was that you were also going to seek to introduce some of the victims' financial records. Is that not happening? Okay, other than that, it's already, okay, all right. How long do you think on cross in this Hughes? Just try to map out the evening. Okay. So what we're going to do is we'll finish with Hughes. We will do one of the two detectives, the shorter one of the two, and we'll come back in the morning. I've got Judge Johnson to do my docket in the morning. We can start here at 8:30 in the morning, and the state will put on its last witness tomorrow morning.
May I advise Detective Noyes?
I was just trying to do some scheduling, mapping out schedule. The state's not going to rest this evening, is the bottom line. I'm just telling them to pick a shorter witness this evening of the two detectives, and then a longer one the first thing in the morning, and I've got Judge Johnson to do my docket, so you can start at 8:30, frankly. I'll just find out from the jury what's a good time for them that they can be here. I don't know if they have any child care issues or whatever, so 8:30 or 9 is the latest. They'll put one more witness on there, then they're going to apparently rest their case, and then I'll be turning to you. I have to let you guys know it's personal, but my wife will kill me if, sorry about that reference in this kind of a case, but if I'm not at her retirement party tomorrow at 5 o'clock. So I am planning on going to that. So we'll break around 4 tomorrow, okay? We may not finish with your case, but we can do that Wednesday night. I just wanted to let you know. I don't know how long you have. You said perhaps most of the day.
I don't think it will be.
Maybe we'll get you to rest at before 4 o'clock or 4:30. So I can work as late as 4 or 4:30. But if not, we'll come back, Wednesday morning. I think we're probably moving back a day in terms of our schedule. I got that. I'm okay with that. I just let me cover something else. I viewed 164, and in looking at 164, which are the screenshots apparently taken at the request of the defense of the WhatsApp.
No, that's factually incorrect, Judge.
Oh,
Oh, okay.
160, there's
No,
another.
the screenshots from 328
Oh.
on Highway.
Oh. So why did I waste all my time going through each of them? Okay, I was going to admit them, so you're not conceding something anyway. But, all right, I'm admitting 164 without objection. And then the one remaining set of screenshots were, I think, March 27th screenshots, which you said you hadn't had a chance to look at, and then...
Right, and I object to those, Judge, as a discovery violation because I haven't ever seen those before 30 minutes.
All right, so, State, you have two things to look at in terms of discovery violations. The email, which you have a financial record.
I looked at the financial record, Your Honor. It looks like a record of, the only record that I can find that the state has turned over is the I-99 to the defense.
Just like Ms. Ramsey said at the
Yeah,
bench.
I don't find
So-
anything that has turned over.
Okay, do you have an argument as to, since she agreed to let everything else in, as far as the email, do you have an argument as to why I should let that in?
Yes, Your Honor. First, the state would argue that the discovery violation was inadvertent. There was a record in our file that Colfax information had been turned over to the defense. However, that was not part of it. Secondly, there is no procedural prejudice to the defense because the defense is conceding that there is, that the defense's theory of the case is that this was a heart attack and then the defendant dismembered his father. So there is no change in the defendant's strategy by introducing additional evidence of the financial motive when there was previously evidence of the financial motive.
All right, so I need to look at the email for two things, procedural prejudice and relevancy. And if you make a copy of it for me, I'll do that. What's the procedural prejudice before I look at it? You want me to wait till I looked at it before you make your argument? Assume for a second that it's inadvertent, given the number of voluminous stuff that we have here. The state's...
Well, this is a particularly significant fact.
Okay, all right, so it's not trivial in your view. You believe it's substantial. And is there a procedural prejudice?
Well, yes, because the significance of that is that the email is talking about this pressure building for a 3-month only contract that he had for employment, and
Right.
it was running out right at the time that this happened. I mean, obviously, that's extremely significant. We didn't know anything about it. I mean, now that we didn't have any of those checks either. I
know
didn't
that.
object to those because we did have the 1099s and stuff, but, you know, the email I consider to be extremely significant.
Oh, this is the one you just submitted? Okay.
I mean, what we've already have in the record here, frankly, is the income from this stream source ended in the beginning of March, middle of March. You've got that in the record already from the witness, right? Correct. True. And you have that amount of money, it's already in the record, which is de minimis compared to his other previous income.
Correct. But the state's argument is that this shows that there's a formal ending of the association between the two.
That's the problem, we didn't know that.
Okay.
But again, there is no procedural prejudice to the defense because their argument has always been, yes, there's this financial motive, but he didn't kill his father, it was an accidental death.
We didn't say that. We didn't say like there's a financial motive. No one's ever said that on this
That's fair,
side.
I apologize. I misspoke,
No,
but-
she has not. What she has said was that everything financial that was done in this case from the defendant was done after the victim's demise.
Correct. But they
That
were-
prior to his demise, you know, the relationship was perfect except for bickering about who's going to get the number of strokes on a particular round of golf. And, you know, basically that was it.
This doesn't change that though. This doesn't it doesn't change anything from what they would have done in their opening statement. They indicated he is cash business and he sells drugs, just he has some type of cash.
So I'm going to look at this following way, okay? First, I find it to be inadvertent. I'm not going to go ahead and say that you specifically planned to not give this email. Like the rest of these documents, this was totally inadvertent. However, you did not discover them, so there is a discovery violation. And it is substantial in this sense, that it tells that the contract that the defendant had with this company ended in March. And you know what? They were gracious enough to allow the other records in, which establish what you want to establish, that his stream of income ended in March. And I'm going to go ahead and disallow this email communication, finding that it is procedurally prejudicial to the defense. And so we will remove from Exhibit 144.
D.
Okay, it says A through D, but it's
It's
actually D. We'll remove that email, and that will be admitted without the email. All right. No. 144D is in. She marked that A through D on the back. It really should just say 144D on that. That record is 144D. A part of it, just one document. The email is being removed on a discovery violation in this case. So left for me to look at are the March 17th, March 27th screenshots. And do you have those? These are the March 28th ones there, Mr. Parnafiello. I'll give them back. Just as well. They're going to be admitted without objection. So do you have one, whatever the March 27th screenshots? That's the last thing I have to look at on your list of stuff, and then I've ruled on everything, I think, right? So one March. So when did on the screenshots of WhatsApp? You guys got together, got the phone. Mr. Argazal was able to reactivate the WhatsApp application. He took photos of March 28th, and you have now marked them without objection being admitted as 164, correct?
Their investigators took those photographs, yes, sir.
Right, got it. Well, when I said Argazal, I meant the defense team.
Yes.
All right. Did you take the March 27th screenshots at that same time?
Not in the presence of defense counsel, but
Privately, in your own bunker off to the side somewhere?
oh, correct. And the state's intention is going to be published through the use of the phone itself on the Elmo, the information further back in the text. However, there'd be no record of that. So what I did was take screenshots and print them out today before afternoon court to have a record so that we can at least have something that we're talking about, whether or not the court allows it or disallows it. But
Okay, so what's the March 27th one show?
further conversation from that individual asking the defendant for additional money, and it also contains the voice note. There's like a photograph that the jury can see where the voice note comes across. And that,
What was a voice note? Help me here.
it'd be like if I took the phone and I recorded myself and said, "Good morning, I hope you have a good day today." You could send that recording to somebody. So instead of typing it out, it's your actual voice giving the note.
Okay, and I admitted the phone call from March 27th that we have previously discussed, right?
You admitted the voice note from March 27th, as well as two out of the four attempted to be entered voice notes from the 25th.
I entered the WhatsApp call from his side of the conversation, which I had on the CD on March 27th. I admitted over their objection.
Yes.
And what does the screenshot relate to that? Is it just a screenshot of that call?
I did the entirety of the conversation on March 27th. I think it's...
In other words, what we hear, audio is now, when you do the screenshot, is just the written transcription of it?
No. There's writings that go back and forth between the two individuals.
Right.
At some point, the defendant chooses, instead of text back, to send the voice note, and you can see a photograph that indicates the voice note is sent. It's like it's almost like a view of that little player.
Okay, all right. And when did you turn it over to the defense team?
The information was turned over to the defense team on the day that they went there. The photographs were turned over today, essentially.
What do you mean the information was turned over?
You had access to review the
Well, all right, they had access to it.
First of all, Judge, I would object based upon the state not having permission to access this information. This was password-protected information, and we went there with the understanding that we would use the password that belonged to the defendant for the exclusive purpose of accessing the March 28th text messages, because those established the timeline. And that's what we did in the presence of the state. We photographed it, we provided that to them.
I understand your
And so
objection.
apparently the state went back and accessed it again
Correct.
without permission.
Let me ask you this question. When they accessed that phone previously, was it via search warrant?
You could not access this app with the search warrant. They could not download this. This is the reason why we were doing it at the last minute, because the
So
defense had to actually go there.
prior to Friday, the state, while they had gotten a search warrant for the phone and retrieved a lot of information that's probably contained in this email from Parnafiello, which I got, they were not able to retrieve the WhatsApp
Correct.
messages until you came in on Friday and said, we'd like to look at it, we're waiving any chain of custody, we're going to go ahead and do it. And then you did it for the limited purpose of March 28th, took photos of March 28th, but did not do it for purpose of any other day or time.
Correct.
And the state never had the WhatsApp application before.
No.
And they never moved the court prior to March, what was Friday? Whatever the Friday before the trial, right? It's not last Friday, it's a week ago Friday.
Right.
They never moved the court to compel the defendant to give a password. There's some case law out there going back and forth. Actually, two different districts have decided whether that's a violation of the Fifth Amendment or not. The two districts disagreeing with each other. I think the fourth has finally come out and said that it is a Fifth Amendment violation.
Correct.
Right?
Yes.
Okay. So the second, I think, says it's not. Do I have that right, Parnafiello?
I believe so.
Okay. And the fourth, Kelly had ordered it in a case, and the writ taken by the defense was dismissed. Kelly thinking afterwards, well, geez, they're going to agree with the second. But then later they come out in a written opinion disagreeing with the second and holding that it's a Fifth Amendment violation, right? What's your response to that? Because now I understand the issue. It's really a constitutional issue, is more than a relevancy issue or anything else. They provided a password to the defendant, to his attorneys, for the limited purpose that they announced here in court. He went back and did that, and they're not objecting to what they recovered, that you saw.
The limited purpose announced in court was to access the WhatsApp. There was no time limitation during the what we talked about in court.
Right.
So
But
my
here's
position
the
is WhatsApp has been accessed.
Yeah. Here's the difference. In front of them, you didn't say, hey, look, can I see the 27th? And take the photos. You go back into the bunker, the state bunker, and without their permission, express or otherwise, without their permission, access other records with that password already being provided for a different purpose. I think she's got a valid legal constitutional objection to that state. And I'm going to sustain the defendant's objection to the March 27th, unless you tell me factually what I'm repeating is incorrect. I think that when you think about it, you'll say, yes, you're probably right. We should have probably either done it with permission from the defense, done it in their presence, or some other way did it. I agree with Ms. Ramsey. I'm not finding it's irrelevant. I'm not finding it's hearsay. I'm finding that there's a constitutional violation of the defendant's Fifth Amendment privilege, providing limited information to his counsel for limited access, and that the state then, outside the presence of the defendant, without permission of the defense, without a search warrant, access that phone for other records that I am now, based on the motion to suppress here argued by the defense in the trial granting with respect to that limited aspect of the WhatsApp application, March 27th. Okay? That's done.
And Your Honor, for the record, that states I'm positive to it, 169 A through
All right. I agree with Ms. Ramsey on that. What's that exhibit?
169 A
All right.
through O.
All right. 169. Have I ruled on everything that's, I think so. Okay. You guys ready? Let's go ahead and get Mr. Hughes. He's back. He's relaxed. He's tanned, rested, and ready. One of the last person who was. All right.
Jonathan Griffin.
Tanned, rested, and ready. Richard Nixon. Okay. Let's go and turn back to get our jurors in and continue direct examination of Mr. Hughes. Arv is out. Is he? Are we proceeding? We can start without him. Okay. Thanks. Let's go.